a lot of it, a big part of it is trying to get charges reduced. So DUI frequently, you're just trying to get it down to, reckless driving or, failure to maintain lanes, something like that, because DUI is just such a stigmatized offense. They've got a very strong lobby, mad, glad, sad, dad. I mean, they've been very successful in really getting the public and, more importantly, legislators focused on this particular offense. And that really, I guess there's kind of three results from that. One is it makes prosecutors more, particularly, in the state system, they're all elected. So, you got these elected officials, they're going to be harder on DUI cases. The law just seems to get more severe and more severe. Like first offender, there's a carve out to make you ineligible for first offender on DUIs. And then, there's just a focus on it with law enforcement as well. That's a lot of the practice, is DUIs. Okay, we need it to not be a DUI. And you pursue that the same way, really the same way you pursue any case. You start with the facts and the evidence, and where are the weak points, attack the weak points, either through, say, motions. In a DUI, you'd be looking at like a motion to suppress, for example, or what we call a Jackson-Deno if there was a confession, which unfortunately there often are, people, particularly people who've never been in trouble before. And I guess this is the unfortunate irony, is that people who have been in trouble a lot are usually more savvy and do less damage to their case than people who've never been in trouble before. They get in there and, I'm so sorry, I know what I did. Particularly when the cop starts putting on the, I want to help you out, I'm your friend here. People who've never been in trouble will just bite that hook, line, and sinker, and kind of moves the starting line back for us a lot. But yeah, you file those motions, you dig into the evidence, and then you take that to the prosecutor and you say, look, maybe you win, maybe you don't, or depending on how egregious it is, there's no way you're going to win this. And then you start kind of, pushing them back, doing the horse trading and so forth, and, trying to get them off of that DUI. And I've had a good bit of success with that. One area that a lot of people don't think about is the commercial driver's license guys that are really that we really have a hard time with, because the federal government has stepped in and prohibited what they call masking, which is basically reduced sentence for that purpose. So where an ordinary driver, you say, look, you know what we want here. We want the DUI to be something reduced. He'll pay the DUI fine. He'll do the DUI probation. He'll take the DUI courses. But we need this to be something, we need it to be something else, because, whatever, he's got such and such job where he needs to have a company car, or just, DUI is one of those offenses, kind of like what they call a moral turpitude crime, like theft, shoplifting, where any job that's going to run your background check, they're going to see that and it's going to be a red flag. In the case of the moral turpitude crimes, it's like, well, this person is dishonest or a thief. In the case of a DUI, it's like, well, this person, is a drinker, has a drinking issue potentially. So we're talking to him about, well, we need to get this reduced to something else. When it comes to CDL defendants, they'll just say, well, we can't, because the feds have actually threatened to remove funding from states, like highway funds, if you violate, if you do this masking with CDLs, which is just a fancy word for, reducing charges. I had to do a deep dive on this actually, because I had a CDL client who, actually I think his license was from out of state, and he was just passing through, but he was in his personal vehicle. That's another thing people don't know. A DUI or a speeding, whether you're in a big rig or you're in your pickup truck, if you've got a CDL, it all counts the same. The case I'm thinking of actually was a county or two over, and he was in a F-150, not a Mac, and yeah, the prosecutor was giving me a hard time about that, not wanting to reduce, and I had to go a little bit outside of your typical sphere of legal research. I was reading attorney general reports and like regulations and things like that. Actually, I recall I ended up going up to Georgia Southern and going to their library and digging up like some old like administrative opinions about this issue. And what I was able to determine and at least convince the prosecutor of was that the definition of masking, it actually has to be by the judge. And I think about every prosecutor in the state thinks it applies to them, but it's actually, for it to be masking, basically you have to plead guilty and then the judge reduces it. The federal government cannot interfere with ordinary negotiations between the prosecutor and the defendant, because, what if the evidence doesn't support the charge? What if they can't actually win it, at a trial? Then it's not masking, it's just ordinary negotiation. And so using that, we were able actually to save this guy's CDL and get the charge reduced before it went. But really, I was fortunate in that case that I had a prosecutor that was willing to do that and rely on the law that I had found, to get this done. But yeah, CDLs they're a case all to their own.